Well, under Virginia law, it's an automatic certification. So all that takes is us filing the necessary paperwork, a notice to the defendant, to their counsel, and filing that with the court. Then his hearing is actually not a juvenile trial. It is then in the posture of a preliminary hearing, which is a probable cause hearing. Because of the type of the charge. In general, when you consider the death penalty on a case, there's a variety of things that you want to take a look at. First of all, you want to look at all the evidence in that case. Number one, the severity of the case. Number two, you want to look at this individual's prior contact with the criminal court system. Certainly, the prior history is relevant. The violent, and going back to one, the vileness of the crime itself. Age is a factor. Juveniles cannot be subject to the death penalty. But there's basically you get a complete picture. There's a background, other bad acts as evidence that you would use in sentencing. What am I leaving out here?
Well, I mean, capital crimes in Virginia require, number one, a first-degree premeditated murder, and then coupled with another felony. There are approximately 13 sets of felonies within the code, which when attached to a first-degree murder, premeditated, willful, deliberate first-degree murder, qualify as a capital crime. So that's step number one. Is there sufficient evidence to go forward on a capital crime? And if that's the case, then you move to, is this an appropriate capital crime in which to pursue the death penalty? And as Jim was pointing out, there's a two-pronged test under the Constitution, or under Virginia law as well. Essentially, is there a future dangerousness aspect to a particular suspect, or is the nature of the offense itself so vile and wanton that it would qualify under what's called the vileness predicate? So either future dangerousness or vileness, one or the other, and sometimes, very often, both, are a basis upon which a jury can impose a sentence of death. They can find both factors and still recommend life in prison without parole. So really, it's just providing the jury with that option and then letting the citizens make the decision in the context of a jury. I have not seen, I don't recall, and again, I grew up in this region, I don't recall a capital crime in Loudoun.
I don't either.
I mean, in one where the death penalty was imposed by a jury and then affirmed or ratified by a judge and then sustained on an appeal and actually carried out with an execution. I don't recall one from Loudoun County. When we probably back in the 30s or 40s.
When we had the Dontrell Hall case, which we charged him with capital murder in a homicide here in the eastern end of the county, that brought that same question out at that time, and we looked into it a little bit because just out of curiosity with some media and whatnot, we asked one of the individuals over in the circuit court clerk's office, and they did come up with a name, and I think it was a case in the 40s or 50s where an individual was charged with capital murder in Loudoun County, and I don't recall the name off the top of my head right now.
Were they actually executed?
Well, and that I'm not so sure of either. It may have been, I just don't recall off the top of my head, but there was one about 50 years ago. And that's all that anyone could come up with at that time.
The odds are, with the dramatic population increase, just probabilities would suggest that you're going to start seeing them more often in a county like Loudoun. Same thing happened in Prince William years and years ago. When they saw their population rapidly increase, you saw an increase in the number of capital crimes, and now Prince William County is one of the jurisdictions that has the highest number of death penalty convictions.
And it is going to come with population. You're going to get increase in volume of crime. You're going to get a wider spread in variety of crime. If you go to a lot of these rural jurisdictions in Virginia, you're not going to see a lot of activity generally. You know, like Jim said earlier, you know, these types of crimes and any types of crime, that you get ebbs and flows, and I don't know that I would attribute it to one variable necessarily. In the last 5 years, we've seen anywhere from 1 to 5 homicides in any given year. We're still within that range, but certainly we've got several months to go before this year is done. But I don't know that I would be comfortable saying, yes, we can attribute this to one particular variable.
Okay.
Well, number one, the narrowing of the window with respect to charges with regard to particular individuals. And then number two, the timing of the prosecutions. It would be pretty rare to have everybody prosecuted at one time, so it's likely that the prosecutions of individual suspects in any joint criminal enterprise are going to be spaced out over time. So this is going to take some time to get through the court system. Don't expect this to proceed rapidly. Rather, it will proceed, like a lot of cases, in a more methodical and slow manner. There'll be a lot of pretrial motions. There always are. Arguments before trial about everything ranging from the searches that may have been involved to the propriety of capital punishment in general, and everything in between. So there's a lot of litigation that's going to go forward in connection with each individual's case. But the timing, the types of charges and against whom, that all remains to be seen.
And I think that people should be comfortable with the experience that we have in our office. We've got a well-trained staff of attorneys here. About half of our staff has either been involved either as a first chair or second chair in either a capital case or a homicide. So we've got a lot of experience here, and we're positioned so that we're ready for this type of thing. We don't want it to happen, but if things like this happen, we are ready.